Saipem S.P.A. and others, and Petrofac Ltd. and another.
Yes, morning, Mr. Thornton.
Lords. My Lords, in this matter I appear together with my learned friend Mr. Colclough on behalf of the Appellant, Samsung and Saipem. The respondents, the planned companies, are represented by Mr. Allison, Mr. Phillips, Mr. Perkins and Ms. Wilkins, and the ad hoc committee of creditors also appears by Mr. Bayfield and Dr. Mokel. My Lord, I think the only point of housekeeping is to update your Lordships on the possibility of a slightly shorter time estimate. So Mr. Allison and I had a short chat this morning, and I think both of the view that we might not need the full 1.5 days, subject to questions.
Well, interestingly, we think that you'll be hard pushed to get it done in 1.5 days.
Right.
So you have 2.5 days.
Yes.
You understand you have the Wednesday. We've done our best with pre-reading, given the reading list we were given, but certainly from our point of view, we would be much assisted by being taken through the reports and the numbers and the structure more slowly and carefully.
Yes.
And it's particularly relevant to ground 2.
Yes.
And we certainly don't want you to feel under pressure to finish by lunchtime tomorrow, because I think from our perspective, we do need to get a better understanding for ground 2 purposes of the detail. We were just, for example, asked to read the reports, but without any real assistance as to how to work through them. And so I suspect when you're opening and when Mr. Allison opens, you should take us more slowly through the numbers. And so, for example, your skeleton argument didn't cross-reference some of the numbers you rely on to the bundles, and you certainly should do that. And if that is the case, I certainly don't want you to feel under any pressure at all to finish by lunchtime tomorrow. That's unusual for the Court of Appeal, I know, to say take more time, but this is a case which may need more time.
Yes, just so you're aware, to see the direction of travel from my point of view, our main reliance on point 2 is actually the issues that were not dealt with in the judgment rather than the issues that were dealt with in the judgment. So in particular, the comparison between the treatment of my clients and others who rank equally with them in the relevant alternative, rather than going back in detail over the grounds as between my clients and the secured creditors, which was the main driver in the judgment.
I mean, again, without wishing to preempt anything, I mean, we certainly want to understand the arguments and the materials in relation to the new money and the work fee, which are 2 aspects of the appeal.
I don't think we're taking the work fee point.
Right. Well, okay, well, you can, fine, let us know where you are. I certainly not, I understand you saying you're not taking it as a standalone point.
Yes.
But I think it is part of, as I understood.
Essentially, we say that when one looks at the judgment and looks at what was not dealt with, there is a freestanding point there, and then when you throw that into the mix, as it were, as the general discretion, all the other points come back in at that point.
Right, that's helpful on timing. I should say as well, we do plan to take a break mid-morning, mid-afternoon, just a short break. So if you can find a convenient moment when making submissions.
So if I aim for sort of halfway.
Yeah, but as I say, subject to what you obviously take your own course, but I suspect you may find you take most of the day rather than less.
So my Lord, unless I think there are also some. I don't know if you have Opus 2 screens on your desk or not. That it's not something that we're proposing to take you to, but I understand that the bank companies may want to put documents up onto the screen in due course.
Right. Well, we have an Opus. I think we all have an Opus screen, which is blank at the moment, and we're getting transcripts, I understand, at the end of the day.
Yes, that's understand it. That's right.
That's fine. And I think otherwise, I'm working from an electronic bundle, so is Lord Justice Zacaroli, and Christopher Floyd's working from hard copies. So but I hope The
I
bundle.
don't think that present. I don't.
I think the bundles, from what I've seen, are the numbers are the same, which is excellent.
That's right.
Okay.
So my lord, just by way of introduction, as your lordships will have seen from the judgment, in the first instance, the judge distilled the sanction hearing into three key points. The first was whether the relevant alternative was, as the plan companies and the ad hoc committee advocated, a group-wide winding up under which there would be no continuation of the business of the group, or, as we advocated, a relevant alternative being a different restructuring on the terms of an offer made by Samsung and Saipem to the plan companies. In relation to that issue, having heard the evidence, and in particular the evidence of the CFO of the plan company, Mr. Souza, the judge held that in the event of the sanction not being granted, there would not be sufficient support nor time for our alleged relevant alternative to be implemented. And as a result, the relevant comparator was a group-wide winding up. Now, although my clients don't agree with that outcome, we are not pursuing an appeal in relation to that first point. So for the purposes of this appeal, the relevant alternative to the plans are a group-wide winding up.
And it was a group-wide winding up, not an administration.
Yes. Which did not involve any continuation of the business. Essentially a proper winding up, if we call it like that. The second issue addressed at trial was whether, assuming that the relevant alternative was a winding up, the jurisdictional no worse off test was satisfied. And that issue focused on the fact that one of the consequences of the plans being sanctioned will be to preserve the Petrofac Group as a competitor of Samsung and Saipem, but with the plan companies relieved of their obligations under what was known as the Clean Fuels Project, which is the Thai oil project. Under both the plans and the relevant alternative, there will be a significant shift of liabilities from the plan companies to Samsung and Saipem. However, in the case of the relevant alternative of a winding up, that comes coupled with Petrofac ceasing to exist as a functioning group and its exit from the market, leaving Samsung and Saipem with one fewer competitor to deal with. The plans are sanctioned. Samsung and Saipem do not obtain the benefit of Petrofac as a competitor exiting the market. They also face the prospect of a leaner, well-capitalised Petrofac competing against them. In short, and as I'll come to in a moment, the judge found that what he called indirect financial benefits arising from the relevant alternative were subject to an issue of remoteness within the scope of Section 901G, and that in this case, Petrofac's exit from the market would constitute such a relevant financial benefit, as it would be a benefit enjoyed by Samsung and Saipem in their capacity as creditors of the plan companies. However, ultimately the judge held that the no worse off test was satisfied on the basis that the indirect financial benefits arising by reason of the exit from the market were too remote. As I will come on to, we say that in reaching that conclusion, the judge erred, and that having made the factual findings that he did, the judge ought to have gone on to hold that the Section 901G test had not been satisfied, and that accordingly he had no jurisdiction to sanction the plans. Essentially, we say that there are two flaws within the judge's reasoning. The first was that the reasons he gave in support of his holding that the consequences were too remote don't stand up to scrutiny on their face. This ground of appeal assumes that the legal test applied by the judge, that the relevant indirect economic benefits arise qua creditor, is the right approach. Our alternative is to say that the judge was wrong to hold that a dissenting creditor who has been subject to a cram down has to show that the adverse consequences impact them in a particular capacity, and that a sufficient connection test is to be preferred. We say that the no worse off test is a fundamental safeguard built into the statute to ensure that, as the words of the statute very plainly and simply say, the dissenting stakeholder can only be forced into a bargain which it is not consented to, where that bargain does not adversely affect its interests. That is our first ground of appeal. Our second ground of appeal is not a challenge to jurisdiction, rather an appeal against the exercise by the judge of his discretion to sanction the plan. And at this stage, I just wanted to identify what we are challenging on this appeal and what we are not challenging on this appeal. We accept, of course, the difficulties usually faced when seeking to challenge findings made by a judge at first instance for all the usual reasons. However, in this case, we say that the judge was wrong on certain issues, in particular that the judgment shows on its face that the judge at first instance failed to engage properly with the question of whether Samsung and Saipem's treatment, when compared to those with whom it ranks equally or ahead of, was fair. We say that the judge, when considering the position of Samsung and Saipem as against others with whom it would rank alongside in a winding up, wrongly focused on just one type of creditor, namely the shareholder litigation creditors, and failed to engage with how the treatment of Samsung and Saipem was different from, for example, a creditor in relation to a project in Lithuania whose claims are left entirely unimpaired by the plans. We say that this leads to two consequences. First, we say that the judge, by restricting his application of the horizontal comparison to comparing the treatment of Samsung and Saipem to the treatment of the shareholder litigation claimants, erred, and that had he considered the position as regards other types of creditors, he would have held that the plan companies could not provide satisfactory justification for their treatment of Samsung and Saipem and the departure from the pari passu rule. Second, and in the alternative, we say that even if the departure from the pari passu rule in that respect does not, taken on its own, justify refusing to sanction the plans, when one looks at the plans in the round and takes into account, in addition, the treatment of Samsung and Saipem in respect of other creditors more generally, and the lack of value to address the competition impact, means that the plans do not justify a sanction order in the exercise of the court's discretion. So the second point is a sort of death by 1,000 cuts. So, my lord, that is in summary our second ground of appeal.
So there's no challenge then to the issues concerning the return in relation to the new money or the uplift to the deputy creditors in relation to the
There is, my lord. It comes in at that second stage. It comes in that we sort of open the judgment by what the judge didn't take a look at. I can say that in light of that, one has to look at the whole exercise of discretion again. We do take some points on the.
but only as it were once you've got into the room for re-exercising the discretion. Is that the point?
Well, I'm not quite sure whether which door we go through, but we say that in circumstances where, on the face of the judgment, something has been missed, then the question of discretion has to be considered again.
But the only thing you're complaining about being missed is the comparison with creditors ranking equally to you or below you.
We're saying that that's anything that we say that was missed, but what we say is that there was a misunderstanding of the evidence in relation to the relationship between us and the secured creditors.
But your skeleton argument, I thought, took head on the justification for the new money, and
Yes, it does. We take the point
say
that it's a blue book too rich. Yes, we do take that.
and that is, you're not giving that up. So that's going to come in at some point. But
Yes, we are going to take your lordship to that point. Yes.
so your death by 1,000 cuts, as you put it, is that just another way of saying that when you take the component elements of the plan together, that
Yes, so we say that one approach the court could take is to say that you're satisfied and agree with the judge that as between the secured creditors and my clients, the bargain works. But then when you look at it as between my clients and those with whom they would rank equally in a winding up, it doesn't work. And therefore that is enough to justify withholding sanction. The second way of putting it is that actually when you look at everything in the round, even even looking in the round, it falls over at that stage, including considering the new money and the relationship with the secured creditors.
Because as I understood your skeleton, you were saying that this is in effect an unfair allocation of the benefits of the restructuring as between your clients and the secured creditors, senior secured creditors. And that's I thought that from your skeleton was the sort of overview point of which these are component parts.
Yes, that's right.
Okay.
Now, my lord, turning first to the jurisdiction point. As I outlined a few minutes ago, our first ground relates to the no worse off test under section 901G. As your lordships are aware, at the sanction hearing, the judge grappled with the question of how, if at all, the fact that the planned companies are competitors of Samsung and Saipem plays into the no worse off test. And we say, as the judge rightly held at first instance, the issue is one of statutory construction. The judge set this out in section B5 of his judgment, so that's paragraphs 32 to 38 of the judgment. The judgment is behind tab 7 of the core bundle. And that's where he sets out questions, and it's page 207 for the overview, where he explains what the effect on the joint venture is, and then he comes back to the analysis at paragraph 60 to 71, which start at page 225. And the judge set out the questions that he has to address, starting at paragraph 60 of the judgment, 225. Firstly, identifying the wording of the statute, being that the condition being that none of the members of the dissenting class would be any worse off than they would be in the event of the relevant alternative. As the judge went on to say, the statutory test requires him to look at what pertains under the plan, what would pertain under the relevant alternative, and compare them. And at 62, he goes on to identify the key point of contention between the planned companies and my clients, namely whether the comparison between the two counterfactuals are to have regard only to direct financial benefits, or can also have regard to what he described as indirect economic benefits or indirect financial benefits, which is what we said. He resolved that by holding that regard did need to be had to the competition issues as indirect economic benefits flowing to my clients in the event of the relevant alternative of winding up. But on the facts, those economic benefits were too remote for Samsung and Saipem, and that accordingly the test under 901G was satisfied. My lord, he dealt with the authorities in section starting at 63 and drew on, we say these are the right cases, Re-Virgin Active, which he deals with in 63. For your lordship's note, that's tab 13 of the authorities bundle. Deep Ocean, which he dealt with in 64, that's tab 11. And Smile Telecom, he dealt with at 66, which is tab 14 of the bundle. Judge emphasised, my Lord Justice Snowden's use of the words in Virgin Active of primarily but not exclusively in terms of their anticipated returns on the claims. Mr. Justice Trower's reference in Deep Ocean that the wording any worse off was a broad concept and appeared to contemplate the need to take into account the impact of the restructuring plan on all instances of the liability to the creditor concerned, including matters such as timing and security of covenant to pay. And the judge took those statements and went on at 64 to say the door is clearly being left open to matters or consequences other than direct financial benefits. And where the judge found the boundary of the analysis was in paragraphs 65 and 66, where he accepted the argument put by the plan companies that when comparing the position of the creditors under the plan and comparing it to their position under the relevant alternative, you do so by considering the dissenting class in their capacity as creditors. And in doing so, he relied on the passage in paragraph 30 of Re-Smile Telecom, which he sets out in paragraph 66 of his judgment. See it picking up in the second sentence. If they might be worse off in some other capacity as a result of the sanctioning of the plan, that is capable of having an impact on the exercise of the court's discretion, but does not mean itself mean that condition A is not satisfied. So in other words, what Mr. Justice Trower did and what was adopted by the judge was a clear dividing line between consequences impacting a creditor, qua creditor, which are jurisdictional, and consequences that impact a creditor in some other capacity, which go to discretion. And as we say in our skeleton in paragraphs 37 to 43, which are in the core bundle, tab 3, page 28, the judge read into the statutory no worse off test two limitations. The first, as we've already addressed, he accepted the limitation derived from Smile Telecom, that the consequences sustained by the dissenting creditor must be sustained in their capacity as such. And second, he held that there was another guardrail to be imposed, namely that the consequences sustained must not be too remote. The judge then went on to find that we satisfied the first but not the second, that the consequences arising from the competition points were sustained in our capacity as creditors, but that they were too remote. And we put it in...
Was the judge right? Do you say the judge was right to say that your losses were sustained in the capacity as creditors?
So we put it two ways. We say adopting the approach, and I'll go on to say why, adopting the approach that we needed to show we were creditors. It was right to hold that this was in our capacity of creditors, and I'll take you through why we say that in a moment. And we say as an alternative, but that they were not too remote. And secondly, we'll say that actually there may be a better way of putting it than qua creditor. But we certainly say that he was justified in holding that we suffered those or we would obtain those benefits qua creditor.
Presumably you'll come on to explain that.
I will. So we put it in two ways in our skeleton argument, and I think that's, my lord, just Christopher Floyd just preempted me on this. So we say first, assuming the judge was right, that section 901G only has regard to creditor impact, and having found that we suffered the competition consequences in that capacity, he ought to have gone on to hold that the jurisdictional test was not satisfied. And secondly, in the alternative, we say that it is not a requirement of section 901G for the indirect economic benefits to be suffered in a capacity as creditor, provided that the consequence is sufficiently closely connected to the underlying debtor-creditor relationship.
Isn't the logical way to deal with those arguments the other way around?
Well, we say that if you apply, when you get to applying it to these particular facts, you may well find that there's no material difference between outcome. So I was proposing to deal with it on the basis of assuming he was right. We ought to have succeeded. Assuming he was wrong, we ought to have succeeded. If I could take it in that order. And taking those issues in turn, we say, just jumping into the evidence, the finding at paragraph 69 of the judgment, which was behind tab 7 at 227 of the core bundle. The judge found that Samsung and Saipem both did suffer the competition consequences in their capacity as creditors of the plan companies. So what he says there is a joint venture, like the Clean Fuels project, is a risk-sharing endeavour where the potential liabilities are shared amongst the joint venturers, where the joint venturers are competitors, and one of the joint venturers cannot meet their obligations under the joint venture due to insolvency, at least the solvent joint venturers who will shoulder additional liabilities have the benefit of a competitor leaving the market. The plan undercuts this balanced outcome by compromising Saipem and Samsung's claims against the Petrofac Group, while permitting the group to stay in business and compete without the burden of the joint venture liabilities. To my mind, it is difficult to say that these consequences are not suffered by Saipem and Samsung as creditors. And we say that, taking the point my Lord raised with me, that he was right in that regard for three principal reasons. First and most obviously, the plan companies can only seek to bind Samsung and Saipem, and do only seek to bind Samsung and Saipem on the basis that they are creditors of the plan companies. That is the jurisdictional foundation for the compromise between the plan companies on the one hand and Samsung and Saipem on the other. It is that compromise that results in the competitor impact. The adverse impact on competition arises only from the compromise proposed between the plan companies and Saipem and Samsung in their relevant capacities as debtor and creditor. And then we have two further points, which are essentially two
Sorry,
sides.
could you go back? Sorry, could you say it again and a little bit louder, because you had some competition outside.
It's
there.
reversing, I think.
Sorry, could you just say what you just said again?
I'll say that again. So the plan companies can only seek to bind my clients, and do only seek to bind my clients on the basis that they are creditors of the plan companies. It is the plan and the jurisdictional foundation of the plan that it is a compromise between Saipem and Samsung as creditors of the company. That is from where the compromise derives, and it is that compromise that gives rise to the impact on my clients.
Yeah, but that's the bit that I would like your assistance on. I fully understand that you can only bind a creditor to a compromise or arrangement because they are a creditor.
Yeah.
But why does it follow that if the plan has an impact upon competition, that must be suffered qua creditor?
Because my second and third points is that when one looks at the difference between the winding up and the plan, the difference of putting back on its feet the Petrofac Group is done by reason of the plan. It's not only compromises my clients' claims, which contributes towards the success of the plan, but it also provides all the other contributing factors that assist Petrofac in being in a position to carry on trading in circumstances where it wouldn't under the relevant alternative. Everything derives from the plan. It's all part and parcel of the same compromise. And as the judge held, it all arises out of the fact that we are competitors in the market. We came together to do a joint venture, and where a plan impacts all of us by reason of depriving us of our ability to seek a contribution from the Petrofac Group and puts Petrofac back on its feet financially, you can't chisel those things apart and say that they're outside our relationship as a creditor.
But your second point is that it's the plan that gives rise to the impact.
Yes.
But it gives rise to an impact on quo competitor in this regard, not quo creditor.
Well, they're not necessarily different.
They sound different to me.
But we at the moment have a particular financial position. As a result of the scheme, the plan, of that financial position, or as a result of the insolvency, our financial position deteriorates. It's the same whether there's a winding up or insolvency. We're not going to get a full contribution from the Petrofac Group. So that is a matter of consequence under both a known restructuring and a restructuring position. But of course, in circumstances where we are put into worse financial position. That means when we go into the market, we're in a more difficult position. We have to make back those financial hit from future transactions, and our debtor is relieved of those liabilities and gets the alternative, gets the other side of that benefit. So it is relieved of those liabilities, and it's relieved of those liabilities as our debtor. So the commercial imbalance derives from the plan and derives adversely, in our case, through our position as a creditor, and the benefit accrues to Petrofac as a debtor.
But I mean, I understand you face increased competition because of the plan when compared to what would happen if the plan was not sanctioned. But that's looking to the future, isn't it? I mean, it's looking to the position you will be in the marketplace generally in the future, rather than looking back at the status of your claim as creditor.
The evidence was that there is already about, I think, $5 million worth of transactions in which we are competing with Petrofac today.
Yes, but you're not a creditor of Petrofac in relation to those transactions.
No.
So
The
okay.
only debtor-creditor relationship is the one that is proposed to be compromised.
So the competition effect is either looking at other transactions to which Petrofac is not a party, or future transactions to which, by definition, Petrofac is not a party.
Yes.
So how does that affect your status as creditor of Petrofac?
It doesn't affect our status, but it is an indirect financial consequence of the plan. When one's looking at the fallback, the ultimate question of, are we worse off as a result of the plan as against the winding up? We take forward that heavier burden as a result of the plan, and as a result of the compromise of our creditor claim, which has the adverse impact on us and gives the benefit to our debtor. Our load is heavier and theirs is lighter. Now, true it is that only vests in the future in terms of outcome, but that is a financial consequence of the plan that is adverse for us and beneficial for plan companies.
Would you say that's always the position, where a creditor happens to be a competitor in the same market as the debtor, the insolvent debtor, and the debt is completely unconnected to any joint venture? It's just owed money. In every case, you could say, couldn't you, that they're better off by the company going into liquidation because they will lose a competitor in the market. Do you go that far?
No,
if not, what's the difference between our case and that?
We don't go that far. Well, the difference, my lord, is that this is a situation where three competitors went into a particular transaction together. It's essentially the holding of the judge. Went into a transaction together as competitors, and therefore accepted together that if the consequences of that joint venture were going to be adverse, they would all share it in accordance with the proportions that they negotiated between themselves. But what has happened here is, by one of the parties essentially being relieved of their liabilities, but not taking the natural consequence of being relieved from those liabilities, namely ceasing to carry on business, they're put into a separate position. So it's quite different from where, for example, a competitor spots that one of its competitors is undertaking a plan and says, well, I'll go into the market and buy some of its bonds, because then they'd be coming along to the court. And the court would say, and this is partly why we say sufficient connection is maybe a better way of looking at it. The court would simply reject any suggestion that there was either a creditor connection or a sufficient connection with the relationship. It's a very particular set of facts here. Three large competitors joining together to take on a large project, incurring an enormous adverse liability, and then one of them walking away from that, but in circumstances where they are, through the plan, put into a financial position where they can carry on business as if that detriment hadn't been incurred, and in circumstances where their competitors are left not just to pick up their own agreed proportion, but to split the additional proportion that would have been Petrofac's. So, my lord, we say that the judge was right to hold that we suffered those financial consequences or indirect financial benefits in our capacity as creditors. The judge, having reached that conclusion, and this is where we do part ways with him, he held that there was a further guardrail, a test of remoteness to apply, and said that we failed that test, and as a result he got to the point of holding that the plan companies could show that we were not worse off as a result of the plans. Now, he dealt with his analysis, as I said, in section E of his judgment, which starts at page 29 of the judgment, which in the core bundle is tab 7, page 225, and he deals with this point between paragraph 67 and 71. In 67 and 68, he introduces what he describes as the need for a test of remoteness, and draws a distinction between direct financial benefits, which he says will always be taken into account and will always be sufficiently proximate, and therefore not subject to test of remoteness, and then the indirect financial benefits, where he says that a test of remoteness will come into play. In the first sentence of paragraph 69, he uses a remoteness test and appears to explain the capacity rule.
I mean, just out of interest, I mean, I obviously, in a sense, I can't remember what I said in Virgin Active, but I don't think you get this concept of remoteness from anything I said in Virgin Active. And so Mr. Justice Trower is in the frame for Deep Ocean and Smile Telecom, but where do you actually get it from?
It doesn't come from the existing authorities. So he took the Smile Telecom. I think what's happened. I think there's two ways of looking at how he addressed this. I think one way is he took Smile Telecom and said it's got to be qua creditor. And once he got there, he then said, but in this particular case, these consequences are just too remote. Or he says that the core test is one of remoteness, and the Smile Telecom's test is just an example of that. So it could be too remote if it's not in the capacity as creditor, in which case it comes in at the discretion test. But he would say, potentially, I think this is what he may have been saying, that even if it comes in the capacity as creditor, it may be too remote. It's too difficult. As we'll come on to, one of the things the judge said is that it's very difficult to quantify. How do you actually resolve this issue as a matter of fact if you are dealing with a situation where there's an impact on the competitor position in the market? It's very, very difficult to quantify. And therefore, should that come in at a jurisdictional stage rather than a discretionary stage where perhaps it's easier to manage?
But that something is difficult to quantify is a curious test of remoteness. I mean, remoteness is not normally determined by just how difficult the court might find the task of quantification, is it?
No, and we say that in particular in a situation where this whole jurisdiction involves a significant challenge evidentially, because the court is being asked to, and the plan companies have to put forward evidence to sort of crystal ball gaze about what might happen in the future in relation to the relevant alternative. So the extreme of that being Thames, where the evidence looked through not just the restructuring plan that was before the court, but also what was anticipated to be the future holistic restructuring, where there were sort of no plans at all for that in terms of what its terms might be, who the parties might be, and so forth. So we would say that one of the problems with this test is that it is very, very difficult to essentially say, well, just because it's difficult for the court to put a number on it, it falls down at the jurisdictional stage. I think there are essentially four reasons the judge put forward for applying this test. The first one, and they derive, I think, from paragraph 70. The first was that the benefit was indirectly sustained and hard to quantify.
So these are reasons for coming up with the remoteness test
This-
or this application.
I think this is why he applied. I think this is why he applied it. I think it's fair to say this was his test. I think answering Justice Snowden's point, I don't think you find this test in any of the authorities. But having reached the conclusion that we were creditors, we suffered we would get these indirect benefits as creditors. On the face of it, absent caveating that in some way, he would inevitably have directed that he didn't have jurisdiction to sanction the scheme. So it's a sort of a reverse out of where he would otherwise get. The second point he took in paragraph 70 was that the appropriate time to take issues such as the competition issue was at the discretion stage, jurisdictional stage. Third was...
But that again, why is that a test of remoteness?
I'm going to take these in detail in a moment. I was just trying to identify what I think the points are. Apologies. I think the third point was that the analysis needs to be subject to a temporal limit. So the focus, and this picks up a point I think that my Lord Justice Snowden was alluding to before. Focus needs to be on consequences that have an immediate impact rather than potentially a future impact. And fourth, that the approach advocated by Samsung and Saipem is inconsistent with the rescue culture in Part 26A. So I was going to take each of those in turn. So taking the first, this is the consequences indirectly sustained and very difficult to quantify. We say that using the term indirect is not particularly helpful to the analysis. At other points of the judgment, for example, paragraph 49, Roman 3, which is at page 219 of the core bundle, the judge points out that my clients will benefit from, under the plan, from the consideration received by Thai Oil. And that's on the fairly straightforward analysis that if and to the extent Thai Oil recovers monies under the plan, they have a smaller sum to pursue us for the Thai arbitration. And that is, in the same sense, an indirect benefit of the plan for us. It's not conferred on us directly under the plan, it's conferred on Thai Oil, but has a knock-on effect for us in an economic sense. And we say that...
But sorry, just to be clear, what you're saying there. So Thai Oil has the claim against the three joint venture partners. It recovers from Petrofac under the plan a certain amount, which reduces by that amount the liability of the remaining liability of Samsung and Saipem. And as a consequence, any claim that Saipem and Samsung would have for contribution against Petrofac is reduced. So you can see that there's a direct connection between that payment and the amount of the claim that Saipem and Samsung would have against Petrofac. So, I mean, that's a direct effect on. I mean, it happens through two stages, but at least it's clearly in the capacity as creditors, isn't it?
Well, or put it, how we put it, it's a direct. There's a sufficient connection between the debtor and creditor relationship, which is how we put it in our alternative.
Right. It's a connection of a very different type
It's a more proximate.
change to
it's a more proximate
than to competition.
Yes, but in one sense, it's indirect. I take the point. And we say that, but coming on to the main point, we say that the answer to the question does not lie in distinguishing what is easy to quantify and what is difficult to quantify. And we make 4 submissions in that respect. First, the no worse off test itself carries with it a need for a planned company to provide complicated and difficult evidence. A planned company has to show that creditors are not worse off than under the relevant alternative, and therefore are required to adduce expert evidence as to what is likely to happen in the event of the relevant alternative, often a winding up. That involves a significant element of crystal ball gazing and the need to put economic values on various outcomes. And as I mentioned, Thames was a particularly stark example of that, because the expert evidence as to outcome looked through not just the bridging transaction, which we called RP1, but also looked through what the impact of RP2 was anticipated to be, which was anticipated to be, and even today remains in the future, a holistic winding up. So that was a complicated set of transactions that it was necessary for the planned companies to produce evidence for on the court to determine. It wasn't simply a question of saying what is the position before the bridging transaction and what's the position post-bridging transaction. So we say that difficult valuation exercises are an inherent and necessary element of the jurisdiction. And the fact that the ambit of the evidence in a particular case may have to be extended to take into account competition aspects is simply part and parcel of the jurisdiction. And we say that there's some support for that in a different context, except in the Chaplin and Hicks Authority, which is behind Authorities Bundles 1, page 792. Now that's essentially a valuation of a chance case. But the court in that case held that the fact that it's a difficult exercise doesn't mean that the court turns its back on the exercise. We say that the same principle applies here. The fact that it may be difficult for the court to determine whether or not balancing the economic impacts of the competition issue against the outcome under the plan doesn't prevent the court from doing, or doesn't relieve the court from the need to do so. And in any event, we say in this case it didn't really matter, because there was expert evidence dealing with the impact of the competition aspects. That was the evidence of Mr. Haslam Jones behind tab 16 of the supplemental bundle. But more fundamentally, firstly, it was accepted that there was existing competition between the parties for about $5 billion worth of contracts, and the evidence for that was Mr. Sousa's evidence, the CFO of the company, at 7.174 of his 4th statement, which is in the supplemental bundle at tab 6, page 208.
I mean, do we need to go to the evidence itself, or are you just giving us the reference?
I'm just giving you the reference, because the more fundamental point here is the judge held that because the benefit of the plan to my clients was so marginal, that it was obvious that the competition aspects would outweigh it.
So, in other words, right. Okay.
So the point about it's going to be difficult to draw a conclusion based on the evidence, he didn't feel was an issue here. When he came in to court on the first day, he made very clear the view he was going to take on that evidence, and therefore wanted to deal only with the question of should he take it into account or should he not take it into account. And he set that out. That's paragraphs 34 to 37 of his judgment, which is, again, just giving you the reference. It's core bundle, tab 7, page 208. And the fourth point is that we say that the no worse off test is an important threshold that the plan company has to overcome in order to put itself in the position of inviting the court to exercise its discretion to sanction the plan, taking into account the whole gamut of discretionary issues. And we set out in our skeleton argument at trial various statements made in Parliament that made very clear that the no worse off test was an important protection for creditors. And the reference for that is tab 25 of the supplemental bundle, pages 971 to 974. For anybody working from hard copy bundles, I suspect that's in the third supplemental bundle. Picks up at paragraph starts at the foot of 971, essentially starts running through from 972. We say these are all essentially to the same effect. That it's a fundamental part of the jurisdiction that the no worse off test must be satisfied. That's at various points in the parliamentary debates.
So just looking at these issues, so for example, are you saying that it's Parliament envisaged that if, for example, an employee who obviously would have a status as a creditor to the extent that they hadn't been paid wages or some other contractual entitlement, but could say, well, I'm going to be worse off because of some other effect that the plan has on me, which has some much more indirect reputational benefit or some other sort of employment related disadvantage that would have to be taken into account at the jurisdictional
But what I'm
stage.
not grappling with here is this qua creditor. What I'm grappling with here is the suggestion that having succeeded in showing qua creditor, a second test is applied of remoteness. And the argument I'm grappling with here is the argument that it's difficult to quantify. We're saying that when one looks at questions of difficult to quantify, it'd be rather strange if that was to have the impact of removing from a creditor the protection that Parliament so clearly intended to adopt.
I mean, the learning on, if we're going back to history, as it were, pre-26A, under schemes, the whole sort of concept of no worse off only ever came in, I think, with Mr. Justice David Richards, as he then was, sort of saying that almost as a matter of inevitable exercise of discretion, the court would never force a scheme onto a class if they would be worse off under the scheme than they would in the absence of the scheme.
Yeah.
I'm trying to avoid using the words that are in actually
Yes,
part
yeah.
26A, and I can't remember the case. Was it? It might have been TNN.
Yeah, but of course, in that jurisdiction, that's the point I come on to about rescue culture. Of course, you only get to consider that question if you've managed to persuade the statutory majority to support it. So,
I fully understand that there you've got a the court would be second guessing a affirmative vote in all classes.
but a heavy burden. I mean, a heavier burden would lie on a company seeking to.
But he, I mean, even I mean, I thought again, I haven't got it instantly in my head, but Mr. Justice David Richards was talking about financial consequences in terms of the claims of the creditors in a direct sense. I think he made some comment about, for example, whether they'd be paid earlier or later. It's the sort of factors that Mr. Justice Trower was mentioning in the extract from Deep Ocean.
Yes.
You know, for example, you know, matters such as timing and security.
But Deep Ocean he was considering that in a particular set of facts.
Yeah.
He wasn't considering this particular position. So what the court is essentially doing under 26A is essentially putting itself in the position of the creditors and saying, notwithstanding that you have not approved it yourselves, we're essentially going to provide the assent in your place. And when we come to the question of rescue culture, because it's always said, well, of course, not sanctioning the scheme would be inconsistent with the rescue culture. But we say, well, the rescue culture that you find, what it means by what Parliament adopted in the statute and the removal of certain obstacles.
But if we go right back to the basics of class, I mean, the class is determined by reference to rights against the company.
Yes.
I mean, and interests such as competition, your ability to compete in the marketplace, would not feature in the class composition test. So why do they sort of suddenly come in at...
Save where the court was to hold that even applying the legal rights test, the differences were so different that it would make it impossible for there to be a fair meeting. So Hellenic, of course, would be an example of a situation where if you look at the legal rights in and out, they're the same, because the subsidiary of the buyer, the bidder, under the plan, under the scheme, was still going to buy and sell shares like everybody else, but because it was controlled by the purchaser, they weren't held to be in the same class. So there are certain cases where, whilst that legal rights in and legal rights out gives you the answer in 99.99% of cases, there may still be situations where the court will say, well, applying that test, it still leaves a lopsided meeting. Therefore, I'm going to carve a separate class. Unusual though that may be. But the general proposition your lordship puts to me, yes, I accept. Ordinarily, if there is the legal rights in and out are the same, but there is an alternative interest, that one takes that into account at a later stage. But of course, as your lordship had found in Baltic Exchange, and we deal with day to day with transactions where shareholders have so, for example, employment rights or bonuses that they get in some other capacity, the court will take those into account when determining whether a single class can be comprised, even though those legal rights aren't specifically dealt with under the scheme. So Baltic Exchange, from my recollection, which is the scheme where there was a set of rights under bylaws, from recollection, you took those into account when considering how to comprise class. So one doesn't blinker. Well, it's the point you're just made a number of times. You don't take in a blinkered approach to legal rights. You don't simply say, are they in the scheme or are they not? You look at the legal rights holistically. So, for example, if a director is granted an enormous an off-market bonus alongside being asked to vote on the scheme, the court may well say that that puts the director into a separate class, because the rights they have pre-scheme are so fundamentally different from rights post-scheme.
But if you had, let's say, a class of unsecured creditors, two of whom operate as competitors in the marketplace and would be affected in a competition sense, but all the others are, say, trade creditors who are not competing in the marketplace in the same way, but they're just selling. Why would you, when you were starting out on this whole process of actually trying to identify the class, you wouldn't sever that class because some people were competitors and might be affected, and the others are trade creditors who would be affected, but because they wouldn't be able to supply goods. I mean, you'd just say they're all unsecured creditors if the plan simply, for example, asked them all to take the same haircut, and you would bring their other interests, if I can put it that way, in at discretion.
Yes. But of course, the difference between the two jurisdictions is that when you're coming to consider the exercise of discretion at the second stage in a 26 scheme, you're doing so knowing that the majority of the stakeholders have supported it. And here you are, under Part 26A, the ability of a stakeholder, creditor or shareholder that's sought to be crammed down to have their own say is essentially removed. And when one gets to the discretion stage, one's comparing a whole range of factors, some of which will be relevant to that creditor and some which will be relevant more generally. So, for example, the court may be having to balance an adverse impact on one creditor against the general desirability to rescue the company. What the 901G test does is essentially require the court to look at that particular creditor in a vacuum. You don't get to that discretionary stage unless you're able to show, looking at a particular class of creditor in isolation, that they're not worse off. Because if one thinks about the reason for 26A coming in, and one looks at what it did, it essentially removed various blocks that could be applied by those who had no economic interest in the transaction. So it made it harder for small holders of debt to stand in the way because it took away the majority number test. It introduced the cram down power, and it also introduced a specific provision to deal with shareholders who might otherwise say, if you're doing a debt for equity scheme, you need me to disapply the preemption rights. Therefore, you have to give me something even though I'm completely out of the money. So that was the introduction of, I think, 566A, which specifically provides that an allotment of shares under the Part 26A scheme does not require a statutory preemption proof. Now, in this case, it's been required because the company, it's a Jersey company, it's not an English company, so 566A doesn't help the plan companies. That is a reason why the shareholders are getting something under this plan. So, my lord, we say that dealing with the first point that the judge relied on, namely difficulty of quantification, isn't a good point. The second ground was that, and we've sort of dealt with this as well, was that these issues are best addressed at the discretion stage. And just to canter through what we say about that, that's not how Mr. Justice Trower addressed it. Mr. Justice Trower drew a very clear dividing line by asking, is the impact one incurred qua creditor? If it is, it's relevant. If it's not, it's a discretionary matter. He didn't seek to apply a further guardrail in the event that the impact was incurred or benefited in a creditor capacity. Second, although the judge emphasised the need for the jurisdictional test to be as clear-cut and binary as possible, we say that introducing a remoteness test doesn't have that effect, and if anything is likely to complicate matters. On a practical level, if a competition point is in play in relation to a potential plan, applying a test of remoteness, the company will have to decide whether it is able to satisfy the court that the consequence is too remote, and unless it puts all its eggs in that basket, will still have to cater for the possibility of the court disagreeing and needing to determine the question of whether or not the financial impact led to the creditor being worse off or not. We say ultimately that the answer to this lies in an evidential test. Where economic interests are at play, the court will deal with them by reference to appropriate evidence and balance the impact of those benefits against the terms of the plan and the relevant alternative more generally. We say that pushing off questions of the impact of indirect economic benefits to the discretion stage is an unsatisfactory approach. The statute makes clear that dissenting creditors can only be crammed down if they are no worse off. That is a narrow exercise, as I said, involved in considering the particular creditor or class of creditor in a vacuum or exclusively. It's not a balancing exercise involving looking at the relevant creditor in comparison to other creditors. That is the discretion stage. The statute establishes a very clear and narrow test at the section 901G stage. In this case, the question is, are Samsung and Saipem any worse off as a result of the plan when compared to the relevant alternative? Only if that question is answered in favour of the plan companies does the more holistic exercise that the court applies at the discretion stage come into play. My Lord, I was just about to move on to a
So, I mean, are you saying, I mean, again, just trying to see how this works. You're saying, look, a cross-class cram down is a benefit that a company seeks to ask the court to exercise to force a plan on a group of dissenting creditors.
yes.
And it's for the company to satisfy the court that it can,
Yes.
and it should.
Yeah.
You've got a protection there, they're no worse off, and we shouldn't read that down.
It's the test is the creditor any worse off?
Yeah.
It doesn't say creditor worse off, is there any worse off? You say that's broad wording, and all that one sees in terms of statutory assistance, or in terms of what was happening at Parliament, was those passages that we showed you a few moments ago. It's a broad test. Because once one gets to the discretionary stage, one finds the interests of the creditor sort of subsumed in a broader exercise. So one can quite easily see how impacts on someone's interest can be outweighed by, for example, the broader good. I will take the view that, notwithstanding certain creditors are worse off, taken in the round, the plan is a good one and should be sanctioned. That's at the discretionary stage. So what this is doing is
And you say it's jurisdictional, but it's a jurisdictional requirement that will be looked at the discretion stage, not at the sanction stage, not at the convening stage. And so you're looking generally in the round anyway.
You only know if you're going to have this issue at the sanction stage because you don't know the outcome of the meetings, convening stage. Because the Crandon power only comes into play in the event of there being no sanction meeting. So it's inevitably determined at the sanction stage. But it is, we say it's in the fact you have to, because bear in mind what the court is doing is replacing the decision of the creditor with the court's decision.
Yeah. So what you're doing is you're attacking paragraph 70 sub 2.
Yes, that's right.
And saying actually the judge, you're saying the judge is wrong to think that it's critical that it needs to be a binary, clear-cut requirement, given that it's actually one that is invoked at a stage when the court would inevitably be looking at discretion anyway.
Well, it's potentially the only protection that a creditor might have. Because of course, until Thames, the argument was being made that if you're out of the money, this is it. If 901G is satisfied, that's it, and game over. And that's changed somewhat, as we'll come on to. But when one's looking at the jurisdiction, what 26A did is essentially to remove blockers that could be illegitimately exercised by those that had no economic interest in doing so. They were trying to sort of
Holdouts. Yeah, holdouts.
Hold out with no basis, but just simply to say, for example, a shareholder, you need my consent to allot shares. This is what it's going to cost. So the court said, well, no, we can overcome those. So what 26A is really doing is enabling the court to substitute its view for the view of the creditor. And we say that in those circumstances, any worse off must mean that essentially that they're acting other than genuinely in their own commercial interests. And so when one looks at something like this competition point, you can't say that about these particular clients. The court therefore should be reluctant to set the 901G bar too low, because what the court is doing is the exact opposite of what it would normally say it doesn't do, which is to stand in the shoes of a commercial party and reconsider their commercial decision. So setting the bar at, well, that commercial decision is a inappropriate one is a good starting point.
So for my part, I'm a little confused as to where we are in the argument.
So we're
We're in the world where the test is one that it has to be in the capacity of the creditor. So you're accepting that at this point.
and that we've satisfied, and that test is satisfied.
And you're here, I think, challenging the judge's legal conclusion that there is an additional guardrail of remoteness. You're not here seeking to suggest that your case is not too remote. You're challenging the legal point of the state.
Well, yes, we'll come on in a moment to why we say it's not too remote. We'll say
so I thought that one of the reasons that you just a moment ago gave for why there should be no remoteness test is because it doesn't help on the binary point, i.e. this is a binary question, and introducing a concept of remoteness confuses things. Was that not the point you made earlier?
Sorry.
I thought one of your reasons for arguing there should not be an additional remoteness guardrail is because it introduces a whole range of discretion,
Yes.
which is contrary to the point being a binary one.
Yes, but what the judge has done here is is not take that point on at the quay creditor stage, having got to the conclusion that first we have to show quay creditor, and secondly we have that somehow there is a reason to apply a remoteness test but because it's a sort of related to the point about quantification. It makes life easier. It's all about this is all very difficult if one brings it in as a jurisdictional point, and it's easier to consider it at a discretionary stage.
Yeah, and you're saying if you pass the test, that it is an effect which is felt qua creditor as creditor.
Yes. You move on.
Then there's no other necessary requirement of remoteness you have to satisfy. You've satisfied the test.
And you're worse off. because if you go back to why this is there, ultimately when looks at the change that 26A introduced, they are essentially removing blockers. So if somebody has exercised their vote against a plan for perfectly legitimate commercial reasons because they are worse off compared to the alternative, why should the court stand in their shoes and say, I'm going to restrict the economic consequences that you are concerned about, even though they arise as a direct result of the plan?
But if you go back to the scheme situation, suppose you've got a class which voted in favour of a scheme under Part 26, which it obviously had to give the court jurisdiction to sanction.
Yes.
And you had a minority in that class who had voted against.
Yes.
And if they turned up at sanction and said, this is all terribly unfair to us, you shouldn't be sanctioning this scheme, and the judge says, well, why? All the other people in the class think that the return on the debt is good enough. All the other unsecureds in your class think it's good enough. Why are you saying it shouldn't be sanctioned? And the creditor says, because I'm affected as a competitor, I really want this company to go down because I am a competitor and I would benefit hugely from that. The court would say, sort of on your bike. I mean,
the court's considering at that point at a discretionary stage because
Yeah, but that was the origin of the concept, surely, of no worse off. I mean,
But bear in mind, the difficulty with the analogy is that in that situation, people who are, by reason of being in the same class or in the same position, have outvoted them. So the jurisdictional test and requirement there is that you persuade a majority number representing 75% or more in value of those that vote in favour. That's your jurisdictional tick done. Therefore, you move on to the question of discretion. But you don't have that in a cram-down case. You have no jurisdictional basis other than being able to say, in the absence of a vote, this category of people are no worse off.
but the court would still be looking within that assenting class at the question of whether it was fair, to use an expression, to force the scheme, Part 26A scheme, on somebody who was dissenting.
Yes.
And when assessing whether it was fair to force it on, it could well take the view that as a competitor it would be worse off. But I venture to suggest the court would not have refused to sanction that scheme because that reason for saying I am worse off would not play again in the context of a scheme, because the class as a whole, with their shared rights against the company, would be better off. So why do we bring it in as a jurisdictional requirement under Part 26A?
Because 26A requires the court to be satisfied that we are not any worse off. That is the bar that has replaced the need to seek the approval of the relevant class of creditors.
Didn't Parliament tell us we should be interpreting Part 26A against the background of scheme cases? And this no worse off concept, I think, did come in, and I can't find, I don't know whether we've got the right TNN in the bundle for this, and somebody may tell me, but I can't find where the Mr. Justice David Richards references.
We might the reference, would it help?
Well, only if it's in the bundle.
It is, yes. It's tab 20 of the authorities bundle, page 660.
Tab 20.
Tab 20. It's within, it's cited within my lord's decision in Adler.
Court of Appeals decision, I think, but yeah.
At
Yeah, I know,
paragraph
yeah.
150.
150. Yeah.
reminded that we were supposed to be having a transcript break 15 minutes ago.
Okay.
Is that the time?
Right, well, it's probably a convenient moment. Let's, we'll keep it, it certainly will be under 10 minutes, so let's be back here in 10 minutes' time.
All rise if able.
When you said that bundles, I said, I think you have some. We had yeah. This is your last minute. She literally told me this morning that she felt yeah. No. Yeah, I don't understand. Yeah, cool. I don't have. I don't have. Where is the authorities bundle? That's not me. It's really. There's a platform and available companies. S.P.A. Right. Yeah, it's because they're not referencing it like that. There we go. You okay? You'll be a professional, you know what I mean? You'll be like, guys, sorry, I got you. Just recruiting.
It was too cramped.
Change of roles, you know.
It is. It's just ludicrous. Then yeah, we normally go October half term. That's right. Maybe that's I've always been in Australia for 3 weeks.
It's okay. Even if it's like actually fine because I didn't have a competition in the first place, so it's like I'm kind of not as like mad about it.
I'm so sorry.
So I can kind of think I actually would have. I was a bit more shocked than yeah, anyway, not Wednesday.
Where did you go? Yeah, my family is in York. My brother's got 2 young kids. Yeah. That'll be nice. Yeah, exactly. And we've got home for 2 kids, so that'll be really nice. I just get a long week. It looks so warm. It's 30 degrees somewhere. Crazy.
Yeah, it's just the same.
Yeah, I was about to say that, but you know,
Right.
cold. I didn't realise how it last year. We loved it. Yeah.
Right, table.
We just turned up the extract. Of the passage.
Sorry, could you keep your voice up? Sorry, Mr. Thornton.
Sorry. So I think we just pulled up the extract in Adler of the passage I think your lordship was referring to from Mr. Justice Dave Rich as he was in T&N 661 of the condom. I think it's that passage at the top, which I think the point your lordship was alluding to was a point about immediacy.
Well, I mean, it talks about receiving less, you know, which does focus on what people actually get on their claims. The only parameters around that are timing or security, in truth, which is what Mr. Justice Trower said in Smile Telecom, in effect. He was picking up the same sort of basic point, but none of that really drifts into considerations of wider commercial interests.
But in deciding whether somebody is worse off, you have to compare two outcomes, financial outcomes. One doesn't just simply look at the downside on both sides. One has to look at the downside, the upside on both sides of the coin. Worse off doesn't suggest a restriction on that. And the immediacy point, if to the extent that's relevant, because we talked about it a little bit earlier, well, most of the financial aspects will emerge in the future. Of course, the impact of the plan is immediate in the sense that the financial consequences, the adverse financial consequences for my client are immediate under the plan, and therefore will have to be priced into whatever it does immediately, and vice versa. Now, as the evidence at first instance showed, the Petrofac is still in the market pitching contracts. It's pitching against us for 5 billion of contracts. It can hardly be doing that on the basis that it is insolvent. It must be doing that on the basis that the plan is likely to take effect. So the competition issue is playing out now. And my lord, I think where we got to in the judgment was paragraph 70, Roman 3. And so that's the foot of 228. And we've sort of addressed these points already. And one of the points raised here is essentially a timing point. Certainty in timing. And I've just made the point that here, whilst it may be the case that the returns made on contracts in the future vest in the future, it is the immediate impact of the plan that creates the competition imbalance. It is the plan that puts us in difficulty, and it is the plan that takes Petrofac out of difficulty. And that enables Petrofac to compete now in the market for contracts and impacts our ability. We have to price in the plan, and they price in the plan. We price it in adversely, they price it in positively. And then, last but not least, the paragraph 74 point, which is the apples and oranges point. And this, I think, is the judge having a problem with our approach, that it does not allow the court to look at things in the round and or cuts against parliamentary intent to promote a rescue culture. We say that what the judge has done here is conflate the jurisdictional no worse off test with the discretionary test. We say that when looking at the question of whether the jurisdictional test has been met, the statute does require the court to approach the question by reference to looking at each class of dissenting creditor proposed to be crammed down in isolation. The court is not being asked to address the question at the jurisdictional stage of whether there is a fair allocation as between different groups of creditors, providers of new money. That is the separate and additional test the court looks at if and when it comes to the discretionary test. And I was going to make a few comments about rescue culture. I think I've already addressed these. And that is really to make the broad point that when one looks at what we mean by rescue culture, we find it in the statute, we find it in the provisions that were adopted by Parliament. And I made reference to three, just to remind your lordships, three important provisions of 26A. Firstly, the introduction of the cram down. subject to replacing the need for stakeholder approval with the 901G test. Second, the rather narrower majority requirement, so only requiring a 75% majority in value from an assenting class, no longer requiring simple majority in number. And again, as I referred to, it is 566A. 566A, which whips away the ability of shareholders to sit on a preemptive lead and to hold their hands out. So Parliament expressly removed the need for a planned company to obtain a disapplication of the statute preemption regime in circumstances where a 26A rescue is being proposed. But essentially the key point is that when one looks to find what one means by rescue culture, one looks to the statute and one looks to see what Parliament implemented in order to promote a rescue culture. What it doesn't do is provide a justification for shortcutting that statutory process or to eat away at the protections Parliament adopted for the protection of creditors. The enabling provisions of the legislation are specifically subject to the need to satisfy the no worse off test. It's a significant guardrail. And it's a key facet of the so-called rescue culture. It's not to be taken as an open invitation for a planned company to put forward a plan that does not satisfy the statutory test, and then to say, well, if the plan's not sanctioned, the company will fail, and that is inconsistent with a rescue culture. The proper question is whether it is in accordance with the rescue culture adopted by Parliament. We say that the judge, first instance, placed too much emphasis on the concept of rescue culture. And so we say the consequence of the judge adopting the approach he did, which we say was a flawed approach, was to discount completely, we say, the benefit that would accrue to Samsung and Saipem in the event of a liquidation of Petrofac. Had he not done so, had he just simply applied the test, is this a benefit accruing as creditor, and having found that it was, he ought to have held that Saipem and Samsung were worse off as a result of the plan. And that follows from his analysis in paragraphs 33 to 37, where he contrasted the marginal benefit we get under the plans and the impact of the competition point. My Lord, my submissions to date have been on the basis that two points. It's the point my Lord, or just Zacaroli, asked me earlier. Number one, that the judge was right to apply a test of quay creditor, and that we did satisfy that creditor. Where we part ways with the judge was with his additional guardrail of remoteness. We now move on to alternative case, where we say the wrong test was adopted, and that it isn't a question of asking whether the plan impacts on the creditor qua creditor. We address this in paragraphs 44 to 49 of our skeleton argument. Which is in the core bundle 3. What we say is, when one looks at 901G from a capacity standpoint, it may well be too blunt an instrument, and that a better way of addressing it would be to ask the question of whether the benefits a creditor would obtain in the relevant alternative are sufficiently closely connected to the underlying debtor-creditor relationship that the plan company seeks to compromise. Now, it may well be in this case, given the findings that the judge made about the marginal benefit of the plan as against the impact of the creditor, of the competition point, that it makes no difference to outcome, in the sense that the judge was content on that balance, and he was content that if the quay creditor test was the right one, we fell within it, then we would also fall within this test. There would be a sufficient connection for all the reasons I addressed earlier. But as we set out in 42 to 43, potentially the issue with the quay creditor test is that it doesn't deal with the example we used in 42, where, for example, in comparing the relevant alternative against the plan, one looks at, for example, the ability of a landlord to obtain a better rent in the market. Because in that case, it might be said, the ability of a landlord to obtain a better rent in the market is a benefit it gets from a new contract entered into with a third party, not in its position as capacity as creditor.
Isn't that example all to do with quantification of a claim, though?
No, because what one has to do, if one has, when considering the worse off test, one saying not what would you get in a winding up stop, it's saying what would you get under the plan? Let's say the company had proposed a rent under the plan of 500, but the evidence was if the winding up happens, you'd take the lease back and go and be able to enter into contract at 1,000. You'd be 500 better off. And we're saying, in our case, if there's no plan, we're going to be able to go off to the market, quote lower prices and get more of the market.
But I'm not sure I'm following this example. Suppose, so your example is you've got a landlord that's got a contractual rent of £1,000 a year for 5 years. Yeah. Yeah. Or less, or sorry. Is that right?
Yes.
So you're saying in the relevant alternative of liquidation, the landlord could forfeit, or the lessor could forfeit, and re-let in the market for £800 a year. Rehire, the bailor could rehire the equipment for £800 a year. Is that right? So the plan is just you get 500 a year for the remaining term of the lease. What's the compromise or arrangement? I mean, that can't be what the plan does, because that's not a compromise or arrangement. That's just a. I mean, there's got to be some give or take. There's no give or take.
So you have an existing contract that pays 1,000, and under the
and
the plan,
the plan just says you get 500 for the rest of the. You don't get 1,000. You get 500 for the rest of the term, but there's no give or take there.
Why?
That's all take.
You're getting something. You're getting 500.
As opposed to the 1,000 you're
You're
contractually
getting a
entitled
worse
to.
deal, but you're still getting 500.
So you're saying it? Really?
So you have an existing deal as a landlord that pays you 1,000.
Normally, you have to be given something else to as it were, but the alternative is you forfeit and you get £800 in the market. So I'm just struggling at the moment to see why it's a compromise or arrangement. But anyway, but
well let's assume you get 500 plus a share worth of pound.
Okay, why isn't it still a compromise? Sorry, why isn't it just a quantification question then? I mean, there's nothing outside the question of money passing pursuant to the lease.
Because when you're comparing what happens in winding up, you are looking at what will happen, what the creditor will get when it goes to the market, what the benefit of there not being an existing lease in place between the company and the creditor will be. It's looking at what they can go and do in the winding up. In the same way that here, it is said that if there is a winding up, we can go into the market and do better.
The example, I think, is that the creditor has a reduced claim in the liquidation because it has the ability to re-let the equipment in the market, so its claim is reduced. What's missing from yours is what can it do with its equipment under the plan? Is the plan purporting to interfere with its proprietary rights over the equipment?
Well, I think if on the plan on this basis, it would be requiring the company to access them.
I'm struggling with this example. Actually.
My learned friend's example, so I'm going to explain it rather better than I'm doing.
On the question of proprietary interests, if it was a pure landlord case, there would need it can't interfere with the landlord's right to terminate. The example that we've given is Bail or Bailee, where or a simple contract of hire.
Yes, but the property belongs to the bailor, doesn't it?
It does.
Yeah. So on what basis is the bailor being prevented from dealing with this property?
Well, that's a separate point. The way in which, in a pure landlord, we've seen a number of them before the courts, in a sort of pure landlord case, the way in which the courts approach the question of no worse off, it's not at the prior question of is there give and take, is to say what would the landlord get in the relevant alternative and to quantify it. And the way that the court quantifies it is it looks at the hypothetical contract that the landlord would enter into with a third-party tenant in the relevant alternative of liquidation. And it will measure the value of that money that in the counterfactual would go into the landlord's pocket. The point we make is, if that's right, and I think it's common ground between us that it is right, that's the approach to measuring what the landlord will get in the relevant alternative. The money that's hypothetically in the pocket in the counterfactual from a third party under an entirely different contract is not qua creditor, or at least in the way that the plan companies say that test applies. And I accept it goes to quantification of the claim as well, but that's a different point. You're simply measuring.
You're saying it's if it's anything, it's qua owner of the property with the ability to let.
Exactly, and that's in the way that the plan companies say the capacity test works. So we say that capacity is simply on this alternative ground is too narrow an approach, and what the court is doing in cases like this, the landlord example, is it's just accepting that that hypothetical cash flow under the hypothetical new contract with a hypothetical third party in a relevant alternative is so closely connected to the creditor and debtor relationship that it has to be taken into account. There is an example of the court approaching the question of the relevant alternative in that way. I'll just take your lordships to it very briefly. It's in Revolution Bars, which is in the authorities bundle. At tab 18, paragraph number is 45, which is page 578. I should just say this: the danger with first instance authorities in this area is often they're not argued on both sides. This wasn't argued on both sides. This was the plan company's own approach, and the approach taken by the plan company's experts in that case. say paragraph 45, FTI have approached that calculation as follows. And that's a reference back to the figures in the previous paragraph, which show the relevant alternative return versus the planned returns. A, they factored in liabilities owed to landlords of all classes, including arrears where applicable. There were cases in that particular plan where there were no arrears. B, they've reflected on the likely outcome of the M&A process. That was a case in which the relevant alternative involved a sale through an administration. So, for example, if a successful bidder is assumed to be prepared to take on a lease for a particular Class A site and pay rent going forward, the ongoing receipt of rent is assumed to be a return available to the Class A landlord in question, the relevant alternative. In my question, that is appropriate if likely returns that could be achieved from third parties, such as incoming purchaser, completely ignored in the calculation. The comparison with the relevant alternative would be much too flattering to the plan, and that's entirely right, because if you simply ignored what the landlord would get in the counterfactual through a new contract with a third party, you'd always pass the no worse off test.
The trouble with these cases is that identifying what the plan gives to the landlord is not quite so simple as I think this calculation suggests, because the landlords will have debt claims which are compromised by the plan.
They will.
Then they're usually given the option to terminate the lease.
They are.
And if they terminate the lease, what they get thereafter is a matter of them just contracting in the market. So why is that a benefit from the plan? Or yes, why is it a benefit from the plan? It's not something they're getting under the plan, it's just they get their property back.
I don't think that's the point.
Well, what is under the plan, the numbers in paragraph 44 of resolution bars,
Yes.
what's the judge purporting to set out there?
So those are the returns from the company
On the debt claims.
and on the rent going forward, to make sure there was a like-for-like comparison.
So under the contract as varied.
As varied, yes. You
It's
say
a choice the landlord makes.
it is. It is. That's right. But we're looking at the question of relevant alternative returns here, which is the sort of the column to the left, and all the judge is saying here is when I am considering whether or not this landlord is any worse off, I need to look at what this landlord would get hypothetically in the counterfactual of the relevant alternative.
And actually, was the judge applying the worse off test here, or was he looking at this as a matter of discretion?
But he was, because you can. I mean, that table is about no worse off. It's relevant alternative versus plan, and then he goes on to say at paragraph 49, he accepts the plan company's conclusion as to what the relevant alternative is, and the returns the plan companies could expect.
He's comparing what the landlord in each case could do and would do under the plan, would get under the plan, if it chose to accept the variation to the terms of the lease, on the one hand, against what the landlord could do in, let's say, a liquidation, by recovering its property and reletting in the market. That's the comparison, is it?
That's what he's doing, yeah.
So, my lords, essentially, we say it probably doesn't lead to any different outcome in terms of result, but that it may be better to adopt an approach which is driven off a sufficient connection test, rather than what might be thought to be the blunt instrument of capacity only. And we say that there are alternative approaches for the court. Seems to us that the sufficient connections are the better one. But in any event, unless the court accepts the analysis of the judges to remoteness, in this case, for the reasons set out in paragraph 37 of the judgment, the outcome should be the same. And that is because at that paragraph the judge held that given that the essential difference between the two counterfactuals of liquidation and plan is that Saipem and Samsung's direct financial benefit is only marginally different, but that in one scenario, the plan, the group stays in business and competes, and that in the other, liquidation, it does not. The existence of material indirect economic benefit to Saipem and Samsung is obvious and does not, because of the marginal nature of the direct financial benefit of the scheme, need to be quantified with any precision in this case. So many of the concerns the judge had about quantification and so forth simply don't arise here. You say that if your lordships agree either with the alternative test, or agree that the right test is qua creditor, or indeed adopt the third approach, that it's simply a question of asking a broad question of any worse off. In this case, the answer to that question is straightforward, and the judge arrived at it. Now, my lords, we were then proposing to move on to our second ground of appeal. In light of the comments my Lord Snowden made this morning, Lord Justice Snowden made this morning about the numbers, what we were proposing to do is to split the submissions with my learned friend to deal with the numbers in terms of the senior creditors and the interplay with the new money. Would you like us to start with that, or would you like us to come to that?
Well, in a sense, I think you obviously you'll take your own course, but it would certainly help to go through the expert reports documents, because in your skeleton argument you lift a number of numbers without cross references, and that certainly assist. And I think we would be probably assisted to have ideally some sort of agreed set of numbers, because I have to say I found it, just speaking entirely for myself, very difficult to locate some of the numbers that are in the tables in the documents from which it is said that they emanate.
Yes. Would it assist your lordship to see how we put it first as part of that?
Well, I mean, have a go, and we'll let you know if it does. If you're not assisting, we'll let you know, I suspect.
I think, well, that may make sense. It may be that the issue dissipates, it may be that it doesn't, and in which case.
Yeah.
Yeah, can I just ask this as well, because the numbers in a number of the tables assume a post-restructuring enterprise and equity value. I'm not sure the difference between those two is at the moment for the company going forward.
Yes.
That's based on a valuation report by 10AA, which I don't think is in the bundle, is it? I'm not able to find it. In order to, it may not be necessary the way you run your arguments, but if it becomes necessary, it may be to see how that valuation is arrived at. Now, what is it that gives rise to an uplift of $1 billion or more?
Yes.
In the valuation of this company, because it continues in business.
It continues in business, and in 2027 we'll be making more than £300 million profit.
But
it's a very straightforward. It's an incredibly profitable company on the projections going forward.
right, but I think it would certainly help me to see that valuation report. And the other point is, following up on what Lord Justice Snowden said, there are a number of different figures in the bundles. Some of them assume an input of new money of 350 million. Some of them the 444 million. It would be useful that if all parties were working from the same set of numbers, so we can see real comparisons.
And some of the, I mean, when I was looking at some of the tables that the judge puts in the bundle, in the judgment, I mean, A, I'm not at the moment convinced that some of the numbers aren't actually transcribed wrongly, and B, certainly there seems to be, to my eyes, a clear error in paragraph 85 sub 3 of the judgment, just on its face. So I really, I'd be much assisted by having a sort of clear statement of numbers that everybody can agree. Because the one thing the judge does say in a number of places is that the numbers aren't disputed, but it's just the presentation of the numbers, he says, is in essence disputed, or how you analysed them, but he doesn't seem to suggest that there's any dispute about the underlying core numbers. And so I'm not sure we're asking for anything that's terribly difficult.
No, we don't think there is. There are sometimes some rounding errors. Financial advisors on one side, financial advisors on another, slightly different methodological approaches, but they are rounding errors. There's nothing.
But I think there's more than just rounding errors in places. For example, let me just give you the example that I picked out. At paragraph 85.3. Now, and it might be useful if you've got paragraph 85.3 open with table 3, because this is what the judge is actually referring to. And he says, by contrast, the class of other claims, which includes the shareholder claims and the claims of Saipem, Samsung and Zacaroli, which comprise 3144, are reduced by 93% to 252. Well, if you go back to table 3, the other claims, which is row D, which is 3144, is actually reduced to 66 by 98% or 97%. I mean, he's just read the wrong lines, hasn't he?
He seems to have done.
Well, it's actually an interesting amalgam, because he's lumped in the other lenders who get a much better deal.
Yes.
I mean, your clients, as I understand it, the other claims are reduced not just by 93%, but by 98%. So there's that error, and I must admit I couldn't also, for myself, match the numbers at the right-hand side of table 3 with anything that's in the report. And I wondered whether, again, there was just a transcription error in the numbers. So it would be useful to have the numbers agreed. And I certainly, my understanding is your case, is you're saying, and the skeleton argument, the senior secured creditors are walking off with equity, which is extremely valuable in this very valuable company, which gives them a massive uplift in relation to the provision of new money to an entity which, post-restructuring, is not risky. It's very valuable.
That's the case, yes.
And you say that's just an unfair allocation of the benefits of the restructuring, but it does require us then to understand how you get to the numbers which, for example, you quote in your skeleton at paragraph 13.1.
Yes.
I mean, I think we've all looked at various pages in the experts' reports and tried to get, we think we can see where 1.5 and 1.85 comes, but it's not at all clear because we haven't got the underlying documents, but it would really assist us to understand exactly, because it's a key component of your argument, how that enterprise or equity value, whatever it is, and if there is a difference between the two, what is it, is arrived at.
There is, and slightly unusually for a restructuring plan, the enterprise value is less than the equity value because there's net cash at the company post-restructuring, not net debt. So usually you have an enterprise value and then you take off the debt from net debt to get to the equity value, and this is a case in which it's actually the other way around.
That may be, you may get that from Alvarez and Marshall at page 544, but I would, again, speaking entirely for myself, please lead me through it by the nose, because yes, otherwise I might not get it.
What we're going to try to do over the shorter journeys is to get the explanatory statement and the valuation reports to the court. You can get some of it from the explanatory statement, you can get some of it from valuation reports. Some of it is numbers that were agreed between financial advisors, and which, other than the consequences of those numbers, we think at least a common ground. But
was there a meeting, a joint meeting of experts to produce a joint report?
There wasn't. No. We, in the usual way with plans, plan companies, the judge accepted this, said this was all incredibly urgent. We asked for more time to prepare expert evidence. We weren't given as much time as we wanted. And here we are.
Okay, right.
Can I start with the universe of new money, just so the court understands? I'm afraid at this point we're going to have to go to our skeleton, sorry, to see what that universe looks like. So sorry, it's page 23 of the core bundle, paragraph 20 of the skeleton. So, subparagraph 1, the senior secured funded creditors, that excludes, for these purposes, a fund called Nuttree Capital Management, sometimes called in the paperwork the new financial investor capitalised. They're not entirely new because it's an existing creditor, but senior secured funded creditors excluding Nuttree, a total of 187.5 million US. Debt and equity 50-50. Subparagraph 2, Nuttree, which is a senior secured funded creditor because it's owed 23.4 million. It's putting in 75 million, debt and equity again 50-50. Subparagraph 3, additional equity providers, capitalised A, capitalised E, capitalised P. That's 87.5 million US. We don't know who they are, but they are either all directors and shareholders or a majority of directors and shareholders.
Where's the evidence for that?
I'm going to have to see that in the explanatory
Why do we not know who they are?
Because we haven't been told.
Yeah, but okay. Did you ask?
Well, what the explanatory statement says is that there's a combination of directors and shareholders and a handful of third parties. That's what the explanatory statement says. We never got into the detail of who they were. That's
okay.
There were so many issues to consider. It's a relatively small one, but that's that group, third group. Subparagraphs 1, 2 and 3 take you, if you add those up, 187.5 plus 87.5 plus 75, that takes you to the 350 million. So you'll see that figure in the evidence. So that's where the 350 comes from, those first three buckets. And then the fourth bucket involves what's called the new CBG structure, which is about cash collateral in respect to some performance guarantees that the plan companies need. 80 million US of CBG notes, again capitalised. That's 30 million by the ad hoc group.
CBG stands for?
I'm afraid I can't remember.
Collateralise, something back, cash back?
Cash back guarantee, I'm told.
So this is the receipt of cash by the company.
There's cash. I'm afraid that this point didn't get much focus. It's not a big point of dispute between us. So someone from the plan companies will jump up. There is cash trapped in respect of cash collateral that's had to be provided with performance guarantees. The company wants to find a mechanism to release that. That the CBG structure is the way of achieving that. which I hope is a fair summary of what's going on.
So what are the AHG members and Nuttree giving to the company in return for these notes?
80 million.
But they are giving cash.
Yeah, that's cash. That's cash. Yeah, so that's the CBG structure. So you get 350 million US from the first 3 subparagraphs, plus an additional 80 in respect to the CBG structure at subparagraph 4.
But then, so what about the other 14?
There's something that isn't which is not dependent on the plan. There is an expectation or a hope that there will be a future capital raise from retail investors. Sometimes that number gets added in. It's not part of the plan. It's not conditional on the plan.
Okay, I'm looking at page 544 of the supplementary bundle, which was I happened on this page because it happened to sort of seem to fit.
Yes.
Which is where the 444 number comes from, that my lord said earlier. Because this is where, as I understand it, there's a reconciliation between the enterprise value of either 1.4, 1.75,
yeah,
and the numbers we've just been looking at. Cash collateral, post-restructuring debt, and then there's some other adjustments to reach the 1.5 and 1.85 million, which I think are the numbers that are in your skeleton argument.
They are. So those numbers.
But I mean, you know, I'm still struggling to understand why, you know, I get there.
Well, that's your lordship will see from the valuation report once we put it in. That's the plan company's valuation evidence.
Yeah. No, I understand this is not. It's said not to be disputed, but I'm just struggling to understand what it means.
So, in fact, if your lordship can look at the table on the left of that page first, in terms of how do you get to the 444? You'll see at the top 350, which is the first 3 subparagraphs of our skeleton.
Yeah.
I just took the quote through, and then 9 and 5, which retail equity and third-party equity upsize. The retail equity is the point about the future retail capital fundraise. And then there's an additional 5 that's there. So that takes you to 364, and then CBG, AHG, new investor, that's the 80, and that's how you get to 444. So that's just in terms of what's going in, and I'll explain what it's in a moment. How it goes in between equity and debt. The right hand table starts with, this is based on Teneo's evidence, i.e. the plan company's evidence. See at the top line, enterprise value 1.4, 1.75, and then equity value calculated in this case by A&M 1.5 to 1.855, and then there's a slight rounding error between the enterprise to equity value as between the experts, but it's very, very marginal.
And is this the right page to be looking at? I mean, I just happen to have found this page, but is this the right page to be looking at, or is it explained somewhere else? I mean, is for example, there any other explanation in the materials as to how the 1.4 and 1.75 was arrived at, or do we have to go to the other report?
Got to go to the valuation report.
And is there any and does that also explain how that value is arrived at? I mean, have we got anywhere even a pithy explanation as to why, to put my lord's question, why there's such a big uplift? You know, is it just that you're not liquidating the company and it's a valuable company making lots of money?
Yes, I mean, I don't think we've put it. Obviously, we didn't file valuation evidence. We haven't challenged the plan company's own valuation evidence, so we haven't mean, our economic
I'm,
theories.
I'm not criticising it. I'm just asking a simple question as to whether there is somewhere in the bundle that we've actually currently got any explanation as to what gives this company that very high valuation post restructuring.
Well, it's a company that has historically been successful, has recently been in severe financial distress, a former member of the FTSE 100. It has a large business, shorn of its liabilities, access to cash to performance guarantees. The company thinks that the companies think this is a very valuable business. That's the evidence.
Is that put somewhere in the documents? I mean, you're just telling us that, but is there a reference you could give us? I mean, I'll turn to Mr. Allison in due course, and he can have his go. But are you aware of some statement somewhere in the evidence which explains what you just explained to us? Come back to it.
We'll come. Yeah, if I can come back to it in terms of the evidence generally and the evidence specifically before the court.
Okay.
So that's the universe of the new money.
So you mentioned, I think a moment ago, that there's 14 million was a hoped for potential equity raise, not something that had happened.
That's right.
What's the position on that?
It's not part of the plan formally. It's the plan.
So it hasn't happened.
It hasn't happened. I'm hoping it will.
But that's a relatively small sum.
It is. The terms of the new money. So if the court can turn, I'm afraid, back to the skeleton argument, just so I can set the scene. Your Lordships have just seen that the participating senior creditors and Nuttree are going in 50% as to new money debt, 50% as to new money equity. The additional equity investors are equity only. So with that qualification to what this paragraph says, this is focusing on the senior secured creditors.
Which paragraph again?
Sorry, paragraph 13 of our skeleton.
13.
Now, in a moment, I'll take the court to the comparative report, just so your Lordships understand the way that the debt for equity swap works. But for these purposes, we're just talking about senior creditors who participate and what they get on the terms of the new money. So they participate 50-50 between equity and debt. In terms of the equity component of their contribution, there is complaints about the way we put this in the plan company skeleton. So I'm going to try to put it as neutrally as possible. There is a delta between the assumed equity value at which these creditors are participating and the valuation evidence before the court. So it's 351 million. It's the assumed participation, the assumed equity value which they participate.
Where do you get that from?
It's not. That's not in the explanatory statement at all. We work that out, and that is. Well,
Can we? Sorry, can we just stop the theatrics on the other side of the court? Right.
So,
is there anything that we can fasten on in relation to the 351?
So
in the bundle.
Yeah, there's something in the explanatory statement, there's something in the explan in the PSL. So I will show the court that. I didn't realise this was particularly controversial. Apparently it is. Now the way we have always set out our case is that let's assume a member of the ad hoc group participates and as a result of the participation obtains 10% of the equity in PL, 10%. Our analysis is, and again I thought this was common ground, is that they would pay 35 million 10% of 350 million. But the day one post restructuring, assuming the equity valuations are right, the plan company's equity valuations, they own 10% of a company worth between 1.5 and 1.85. Now, it may be that my learned friends are complaining because that's not focusing on the fact they're also participating in the new money debt, but I'll deal with that separately. But there are certain people who are only participating in the equity. Those are the additional equity providers. We've already seen that.
Well, presumably, if you invest money in return for debt, you can see immediately what that's worth. It's the face value of the debt plus whatever interest coupon there is.
It is, and that's the next subparagraph, my lord. So,
can you just give us a headline number for how much of the total amount is equity and how much is debt? Is it split 50-50? Is 350 split 50-50?
No, because the additional equity providers are not participating in debt, but the CBG note structure is debt only. So, I think for the purposes of this court, our focus is really on the senior creditors and, for these purposes, Nutri as well, because it is an existing creditor, and also the additional equity providers whose we think are shareholders and directors. But it's not quite split 50-50 though. I think it broadly works out that way. So that's the new money equity. The new money debt, which is the next subparagraph, the skeleton, and I certainly hope this is not controversial, is super senior will be in a company which has net cash post restructuring day one, pays 9.75% and will be listed. And just to be clear, this is not a case like Thames in which the complaint is, oh well, you've mispriced the debt. This is a much more fundamental complaint about value that's being given to certain stakeholders. And if I could just quickly...
So the debt is the 288 number, which you can see again at page 544, correct? The post-restructuring debt.
Yes.
Where's the reference to the net cash? How do I get the net cash? Where's that set out?
I'll get the reference over the German, my lord. I mean, in this table at 544, you can get it by adding up the add backs, which is new money, cash collateral release, readily available cash, ICA pledged cash, adds readily trapped cash, and then less cash outflows. So that's a sort of cash inflow outflow, but I'll see if there's somewhere where that can be seen more clearly. And just because it's very early 1 o'clock, and I just want to show you this table before court rises. It's the comparative report. It's the plan company's own evidence. It's in the supplemental bundle, tab 14, page 513. And we've got plan outcomes on one side. There isn't much difference. One's a 350 million outcome, one's a 355. So we'll look at the 350. They're fundamentally the same. If the court just looks at the top two lines, but starts on the right hand side, so we're looking at relevant alternative outcomes. The plan company's evidence is that in the relevant alternative of liquidation, the participating senior lenders, and also of course the non-participating senior lenders, take between 24.3 and 31.9. But in the plan outcomes, the participating secured lenders take between 161 and 202.
But that's blending, isn't it? lending their new money and their equity.
It is, yeah, that's right.
Sorry, and their existing debt.
It is, and in fact, this actually overstates what they're getting because it's gross, not net. It doesn't take account of the fact you've got to put new money in to get those returns. But those figures and the differential between the participating senior lenders and the non-participating senior lenders is driven by that disparity or that delta in what a member of the ad hoc group would have to pay for 10% of the equity and the day one equity value of the group.
Is the return here on the plan outcome for the secured lenders just their equity return, or does it include their debt interest as well post restructuring? So the number of 885 for the participating secured lenders, is that just their equity participation, or does that include their interest on the debt as well?
The short answer is I'm not sure. I think it may be nominal values of the debt only. I mean, the debt's certainly in there.
Well, no, it can't be the debt.
only.
But it's clearly primarily the equity value, I think.
It is. It is primarily the equity value. So there are three main things. There is the debt for equity swap you would get anyway as a senior creditor. There is the return on the value of the equity, and then there is the value of the new money debt that you're subscribing to. You add all those three up and you get to a figure. Whether that third bucket contains interest, I'm afraid.
Well, not leave out the interest. It is the figure of 885. Does it include the three buckets? That is
It does.
debt, equity, exchange for the debt, and equity in exchange for new money.
It does.
All three.
Yeah. And if that's a convenient moment.
Yes. Okay. Well, we'll return it to.
All right.